Good morning, everyone. Our union has many members who are immigrants or who come from immigrant families. As healthcare workers, we care about those we serve, wherever they come from. For this reason, NUHW has taken strong stands in the immigration debate. For immigrants who are fleeing violence or abuse, for families that have been separated, children who are malnourished, those individuals new to this country who did not receive proper medical attention elsewhere, for those who are struggling to adapt to a new culture and often a new language. For all these people, healthcare, and especially mental health issues, are critically important. This morning, we will have a panel of experts talk about what newcomers to this country are facing and what can be done to assist. I'll have more to say about the panel in a bit, but before our panel takes the stage, we are privileged to have with us a special guest, Judge Ashley Tabaddor. And I don't use the word privileged lightly. You see, federal judges are generally barred from speaking publicly about issues affecting their courts. However, there's an exception for the leaders of the judges' union. Judge Tabaddor is not here today as a representative of the Department of Justice, but rather in her capacity as the president of her union, the National Association of Immigration Judges. She is one of only a couple of federal judges, because of the role in their union, who are permitted to speak out about the unprecedented challenges to our immigration system and its courts that have evolved since the Trump administration took office and Jeff Sessions became the Attorney General. We very much appreciate her taking time out from her very busy schedule to be with us today. In an effort to speed up deportations, the Department of Justice is imposing quotas on judges, ordering them to hear at least 700 cases per year or face being fired. I'm sure that Judge Tabaddor will have a lot to say about these unfair quotas, which are scheduled to kick in little more than a week. I'm also looking forward to hearing from the judge about how her union is using collective bargaining and the grievance process to fight for justice, not only for her members, but also for the parties that come before her court. Even judges, it seems, need union representation. Prior to her appointment as a judge, she served as an assistant U.S. attorney for the Central District of California in Los Angeles. She also served as a trial attorney with the Justice Department's Civil Division in Washington, D.C., and as a law clerk and attorney advisor for the Immigration Court and the Chief Immigration Judge. She received her BA cum laude from UCLA and her law degree from UC Hastings College of Law. Judge Tabaddor knows firsthand what it's like to flee one's homeland as a child and come to this nation. Her family had to leave their native Iran after the revolution. They were smuggled into Pakistan during a 72-hour land crossing involving motorcycles and pickup trucks. After a week on the run, they were allowed to enter the United States, sponsored by an uncle who was a U.S. citizen. Judge Tabaddor was elected by her peers to lead her union last year. Prior to that, she had drawn national attention for successfully suing the Justice Department when it tried to bar her from hearing cases brought by Iranian nationals. If she had not prevailed, judges with Latino-sounding names could have been barred from hearing cases from Spanish speakers, Jewish judges from hearing cases by Israelis, and African American judges barred from hearing cases brought by asylum seekers from Africa and the Caribbean. Judge Tabaddor is a fighter who regularly stands up against discrimination and for the constitutional rights of her members and all of those who come before her court. I am glad she is standing with us today. I'm privileged to present to you the Honorable Ashley Tabaddor.
Good morning, everyone. Thank you for that kind introduction, Dan. Thank you to NUHW for the invitation to join you today. It is truly an honor to be amongst such amazing leaders in the community. And frankly, not just any leaders, but labor leaders. I'm mindful that it's Sunday. You could have been so many other places with family and friends enjoying your day, enjoying your weekend, but instead you're here today because of your commitment to a cause much higher than yourself. It is because of people like you and those on whose shoulders we all stand that even the concept of a weekend has a meaning. An 8-hour day, prohibition against child labor, paid benefits, and doing this for you to come here now when there's so much hostility against labor and labor union leaders coming from the Beltway. I have to say, I'm most grateful to have been asked to come and share the stage today with the panelists, but really share the day with such amazing leaders. So I hope to make it worthwhile for you this morning. As was mentioned, I always have to start all my speech or public engagement conversations with a disclosure. I'm here speaking with you in my capacity as the president of the National Association of Immigration Judges, which is the official union of all immigration judges across the country in response to the Attorney General and the Department of Justice. So nothing I say today is on behalf of the Executive Office for Immigration Review, the Department of Justice, or the Attorney General. As was mentioned during the opening remarks, I was born in Tehran, Iran. When I was 10 years old, my parents made the difficult decision to leave Iran, only a few years after a revolution that they were so hopeful for, but which proved to be disastrous, and brought with it the Islamic Republic of Iran. The year was 1982. My father had been actually able to leave Iran in 1981 to come to the United States to accompany my grandfather, who needed quadruple open heart surgery. At the time, it was much more easier to be able to come to the United States to actually seek much needed health care that wasn't available elsewhere. And he was able to come here in 1981 with my grandfather, not imagining the steps that they would have to take a year later. So the burden fell on my mother when the decision had to be made about fleeing Iran, to make all the arrangements and to secure the smugglers. We had to be smuggled out of Iran because Iran required exit permission. So unlike the United States, where you can leave at will, countries around the world, like Iran, prevent their citizens from leaving without permission. And at that point, we had been blacklisted from leaving. So we were smuggled out of Iran-Pakistan land border. Now, what that entails is several days of riding, as was mentioned, riding behind pickup trucks and motorcycles and hiding in villages and caves, and all in the hope of not being caught. And of course, running the risk of jail or even worse by the authorities. So imagine my mother, a woman of 35, a 10-year-old daughter, a 6-year-old son, having to navigate this at that time. So I'm always, always grateful for her courage and bravery. When we made it across the border, the smugglers actually promptly abandoned us, along with all of our possessions. My mother was left with our passport and a counterfeit exit stamp. We were stuck in Pakistan trying to get out and figure out our next step. After 2 weeks of being stranded in Islamabad, we were able to make it to Spain, which at the time was the only country in Europe accepting Iranian nationals without a visa. And it was a practice that they shortly changed after our arrival. We were in Spain for several months, waiting for my father and the attorneys that he had hired to find a way to get us to the United States. And finally, we were able to do that on December 24th, Christmas Eve, 1982, a day that I will never forget. We landed at JFK with a tourist visa initially, and were able to be reunited with, with our family. I remember being ecstatic, seeing my dad. It had been well over a year that our family had been separated and awaiting some way to be reunited. And as I said, it's one of those days that will always be etched in my mind as one of the most beautiful days of my memory. So the rest, as they say, is history. We were safe now, and our family was able to secure our quote-unquote green cards through a sponsorship program or a visa petition filed by my uncle, my father's brother, who has been a long-term United States citizen since the 1960s. But even that process at that time took 6 years to be completed, and it wasn't until my first year of law school that I was sworn in as a United States citizen. But that swearing in opened up doors unimaginable to me, and it allowed me to join the United States Department of Justice as a summer law intern, sort of an externship program, 2 weeks, a few weeks, in the Los Angeles Immigration Court, where I now serve as an immigration judge. I shared this story with you not only to highlight that we are indeed a nation of immigrants and that we do gain from the diversity that we have amongst us, but to provide context on why I'm so grateful to be a United States citizen. This land is my homeland. It is because of my background, though, that I have such a profound respect and commitment to our democratic principles, to the concept of separation of powers, our Constitution, our Bill of Rights, our commitment to rule of law. As the saying goes, power corrupts, and absolute power corrupts absolutely. Our founding fathers' deep understanding of this principle and their attempt to safeguard against it in creating our system of government is truly awe-inspiring. But by the same token, none of our democratic principles will mean anything if people do not stand up and protect them. And that is why all of us are here today, because we understand that words on paper, laws on the books, are only as powerful as the people who are willing to abide by them and protect them. And so when I took my oath of office as an immigration judge, I swore to abide by the Constitution and the laws of the United States. I swore that as a judge, I will be impartial, that I will make rulings on the cases before me solely on the facts and the law of the case. And I meant it. So when during the last administration, as was alluded to during the remarks, when I was ordered to stop hearing cases of Iranian nationals after, now listen carefully, this is very ironic, after being recognized by the White House as an Iranian American community leader, I heard that now they want me to stop hearing cases of Iranian nationals. Took a while. I still don't get it. So I talked to them. I tried to reason with them. I tried to explain this doesn't make sense. Would you ever do that to any other member of the community? And I was basically just stonewalled. So I filed a lawsuit against the Department of Justice. Their action was facially discriminatory and in violation of my oath of office to make sure that I protect the independence of our judges and the independence and the integrity of the court. The department had no right to interfere in cases before me in such a facially indefensible manner. Now, it took 3 years of litigation, a team of lawyers. Thank goodness they were pro bono, because I would have been broke by the end of it. But when the case was finally made it to the district court, And this is, again, another important part, the district court, which is a separate and a part of our government, separate from the Department of Justice. The judge took one look at the facts of the case, confronted the department and said, "Have you ever done this to anybody else?" Of course, they said no, and told them to correct the situation immediately. Now, otherwise, if the department's actions were left unchallenged, today, as was mentioned, the department could have justified prohibiting, say, Mexican-American judges from hearing cases of Mexican nationals, or gay and lesbian judges from hearing claims of people fleeing their country as members of the LGBT community. That could not be left unchallenged. And now, in this administration, the oath of office is being challenged again, and not just on an individual basis. Our immigration courts and immigration judges across the nation are being challenged in unprecedented ways. First, we have over 750,000 pending cases. We have 350 judges to hear those cases across the entire country in about 60 courts. They are hiring more cases and more judges. We have maybe 40 more judges coming on board, being trained and sworn in. But our judges are in court every day, morning and afternoon sessions. We have judges who have upwards of 4,000 to 5,000 pending cases on their dockets. The cases they hear involve life and death situations, people who have been traumatized through threats, beatings, rape, and are fleeing for their safety. Some cases involve children who have been abandoned, abused, or neglected by their parents, or longtime residents who are fighting to maintain their family unity. And under our Constitution, we have a commitment to provide due process to all individuals, all persons, regardless of their nationality or citizenship status. And our laws provide for protection to people who are seeking protection and are fleeing from their country. They have a right to have their cases and their claims heard by impartial decision makers. They have a right to due process. We don't deal with widgets, we deal with human beings. Now, what many people do not fully appreciate is that our immigration court and our immigration judges are in a very unique situation. Unlike the district court judge that I mentioned, unlike our American judicial system that is set apart from the executive branch, for the very purpose of striking that checks and balances that what I talked about before between the prosecutor and the court, our immigration courts and judges are located in the Department of Justice, headed by the top federal prosecutor, the United States Attorney General. So what this means is that I'm forced to wear two conflicting hats. When I enter my courtroom, I wear my robe, I sit behind my bench, I have the two parties before me, I hear their cases, I'm bound by my judicial code of ethics. But when I step off that bench, the Department of Justice treats me as if I'm a regular government attorney subject to the traditional labor management rules where they get to set the standards and I get to follow it. So for those of you who may have been sort of scratching your head at the beginning about judges and labor unions, yes, we need that protection too. But traditionally, that would have been a contradiction in terms, a defective design. This fatal design flaw of putting the prosecutor in charge of the court that is supposed to be impartial is the design flaw that has caused all the issues we're facing and have been facing for many years, but just not to the extent that we're facing these days. So this fatal design flaw has led to both the backlog of the cases as well as the use of the court as a political tool to advance law enforcement policies and agenda. For years and years, the court was neglected. We were the stepchild of the Department of Justice. They didn't know we existed. While at the same time, law enforcement budgets were growing, 200, 300, 400%. And that was obviously triggering more and more and more cases. So just imagine a one-lane highway with an exit ramp. Now add 3 more lanes to that highway, and still keep that exit ramp. Undeniably, you will have a backlog of people. And so too, the court's backlog grew from less than 200,000 pending cases to the ever-growing 750,000. And now the backlog is being used as an excuse to implement the current law enforcement policies of the administration through unprecedented actions which compromise the integrity of the court, the independence of the judges, and the fundamental fairness of the proceedings. You may wonder how. How are they doing this? Well, as was again mentioned, in less than a week, on October 1st, the court is set to enter a new and dark era. The Department of Justice has stated that it will impose quotas and deadlines on judges as a measure of their individual performance. At first blush, this may not seem like such a bad idea. After all, if you have such a large backlog of cases, why not impose some sort of a productivity measures? Well, I'm glad this group gets it, because some don't. So, except as I mentioned, judges didn't cause this backlog, and that's not how the court works. We're not dealing with widgets, we're dealing with human beings. Judges are not supposed to have a personal stake in the cases they hear. Our oath of office requires that we make decisions divorced from any external influences. That is what the parties deserve and expect. But if we're worried about keeping our jobs for not rushing through a case or scheduling more cases on our daily calendars, I would imagine that is not the type of judge you would want hearing your case. That is why independent courts, the courts like the district courts and other independent courts from the executive branch, they use numbers only as a carrot, not a stick. They study their caseload, they study their staffing models, and they use numbers to make adjustments to those, or to provide training when needed. They do not pit the judge's livelihood against the people over whose lives he or she must preside. Just imagine appearing before a judge who is given a total of 2.5 hours for your whole case, when the paperwork in the case would require that much time to review in itself, much less the time necessary to have testimony taken before the court, to deliberate, review, and issue a decision. But that is what the Department of Justice is doing and demanding of the judges. 700 cases a year, amounting to 3 cases a day. Separately, we are facing direct interference with our judges' independent decision-making authority. Recently, the department removed over 80 cases from a docket of a well-respected and senior immigration judge in Philadelphia, all because the department disagreed with the fact that he had raised concerns about the adequacy of notice to the individual who was supposed to come to court. He wasn't showing up to court, and the judge was worried that the notice wasn't legally sufficient. But the department disagreed, so it reassigned the case to a supervisory judge who set it over for a quick hearing and ordered the person deported. The department's action is a flagrant violation of the law and amounts to judge shopping for the decision it wishes to obtain. Again, imagine that you're assigned a judge over your case, but the prosecutor decides that another judge is more likely to see things their way. So they unilaterally transfer the case. What kind of respect could you possibly have for this system? The outcome of such design flaws is not hard to predict or observe. We're actually seeing more backlog rather than less backlog. Cases are taking longer because people don't have trust in the system and are fighting and are trying to make their cases in hopes that they're going to convince somebody else on the appeal level. And judges have to spend the limited time that they have basically turning into bean counters, accounting for every minute of our day and every decision that we're making. And our judges are under tremendous stress and anxiety. I understand that we have a number of mental health professionals amongst us. Thank you for your service. I agree. Everybody can use a good mental health professional in their life. So I suspect that this is an area that you would have some keen insight in. The other day, in response to all of these announced quotas and pressures that are being put on judges, I had a judge approach me and ask me if there was a way to sue the government for intentional infliction of emotional distress. That's how much stress he was feeling. And he's not alone. All across the country, our judges are reporting higher levels of anxiety and stress because of these indefensible and unreasonable measures. And as is, the nature of our work already places us in a high risk factor for mental health challenges. On a daily basis, our judges are hearing stories of individuals who have experienced serious trauma in their home country. A study that was conducted several years ago found that immigration judges are at much higher risk of developing a form of post-traumatic stress disorder because of the secondary and repeated exposure to stories of the trauma experienced by the individuals who appear before them. And I can tell you on a personal level, many years ago, I frankly just stopped watching violent movies. It felt too real. It reminded me too much of what I know through my experience on the bench humans can do to each other. So now adding the anxiety of artificial quotas and deadlines on judges is a formula for disaster. Yet our immigration judges across the nation stand in support of our American democratic values and principles. The due process rights of the parties before the court must be protected to ensure the integrity of our courts and the fundamental fairness of the process. And for that reason, prominent scholars and legal organizations from across the country have formally spoken up in support of an independent immigration court. From the American Bar Association, the Federal Bar Association, the National Association of Women's Judges, and the American Immigration Lawyers Association, just to name a few top organizations, all stand with the National Association of Immigration Judges in calling for a truly independent immigration court established outside of the Department of Justice, removed from the Department of Justice, and divorced from all political influences. So here's my ask. I ask that you stand with us as well. Raise your voices in support of due process for all persons, regardless of nationality, as stated for in our Constitution. Stand up and make those words we hold dear have meaning. Stand up and educate your friends, your family members, your community leaders about these issues and encourage them to get involved. Stand up and contact your representatives on the Hill, the senators, the House members, and demand that they remove the immigration court from the Justice Department and create a truly independent immigration court system consistent with our American democratic values and principles. Let us all stand together as one, for the whole is always greater than the sum of its part. Thank you.